Many states have enacted laws that restrict the teaching of divisive concepts in K-12 schools. In this video, I first introduce the history of laws on divisive concepts. I'll then discuss the impact of those laws on teachers' First Amendment rights in classrooms. On September 4, 2020, the Office of Management and Budget Director released a memo with the subject line, Training in Federal Government. The memo stated, it has come to the President's attention that executive branch agencies have spent millions of taxpayer dollars to date training government workers to believe divisive anti-American propaganda. Employees across the executive branch had been required to attend trainings where they were told that virtually all white people contribute to racism, or where they were required to say that they benefited from racism. In some cases, those training had further claimed that there is racism embedded in the belief that America is the land of opportunity, or the belief that the most qualified person should receive a job. The memo further stated, these types of training not only run counter to the fundamental beliefs for which our nation has stood since its inception, but they also engender division and resentment within the federal workforce. To that end, the Office of Management and Budget directed all agencies to begin to identify all contracts or other agency spending related to any training on critical race theory, white privilege, or any other training effort that teaches or suggests either first, that the United States is an inherently racist or evil country, or second, that any race or ethnicity is inherently racist or evil. On September 22, 2020, former President Donald Trump issued an executive order on combating race and sex stereotyping. One example used in the executive order to justify not to promote race or sex stereotyping or scapegoating in the federal workforce or in the uniformed services was a graphic in the National Museum of African American History and Culture's initiative talking about race. The graphic claimed that concepts like objective, rational, linear thinking, hard work being the key to success, the nuclear family, and the belief in a single God are not values that unite Americans of all races, but are instead aspects and assumptions of whiteness. The executive order prohibited the United States Uniformed Services, federal agencies, and federal contractors from promoting a list of divisive concepts in workplace trainings. It also directed agency heads to identify grant programs for which grants may be conditioned on the recipient's certification that it will not use federal funds to promote the divisive concepts. In the executive order, divisive concepts means the concepts that, first, one race or sex is inherently superior to another race or sex. Second, the United States is fundamentally racist or sexist. Third, an individual, by virtue of his or her race or sex, is inherently racist, sexist, or oppressive, whether consciously or unconsciously. Fourth, an individual should be discriminated against or receive adverse treatment solely or partly because of his or her race or sex. Fifth, members of one race or sex cannot and should not attempt to treat others without respect to race or sex. Sixth, an individual's moral character is necessarily determined by his or her race or sex. Seventh, an individual, by virtue of his or her race or sex, bears responsibility for actions committed in the past by other members of the same race or sex. Eighth, any individual should feel discomfort, guilt, anguish, or any other form of psychological distress on account of his or her race or sex. Or ninth, meritocracy or traits such as a hard work ethic are racist or sexist, or were created by a particular race to oppress other race. The term divisive concepts also includes any other form of race or sex stereotyping or any other form of race or sex scapegoating. Race stereotyping means ascribing character traits, values, moral and ethical codes, privileges, status, and beliefs to a race or sex or to an individual because of his or her race or sex. Race and sex scapegoating means assigning fault, blame, or bias to a race or sex or to members of a race or sex because of his race or sex. It similarly encompasses any claim that consciously or unconsciously and by virtue of his or her race or sex, members of any race are inherently racist or are inherently inclined to oppress others, or that members of a race are inherently sexist or inclined to oppress others. Those definitions are important because many state laws on divisive concepts use the same or similar definitions. On September 28, 2020, the Office of Management and Budget Director issued a memo for the heads of executive departments and agencies with the subject line "Ending Employee Trainings that use divisive propaganda to undermine the principle of fair and equal treatment for all." That memo provided guidance for implementing the executive order, directing federal agencies to review all 2020 trainings related to diversity and inclusion to determine whether they teach, advocate, or promote the divisive concepts identified in the executive order. The September 28 memo indicated that keyword searches may help identify prohibited trainings, suggesting searches for the terms critical race theory, white privilege, intersectionality, systemic racism, positionality, racial humility, and unconscious bias. It also directed that as federal awarding agencies are conducting their review of programs to identify those for which the agency may lawfully impose the condition described in Section 5 of the executive order, they must look at all federal grant and cooperative agreement programs, not just those for the purposes of providing training. On November 2, 2020, a number of federal contractors, subcontractors, grantees, and sub-grantees claimed that the executive order violated their rights under the Free Speech Clause of the First Amendment and the Due Process Clause of the Fifth Amendment. They filed a motion for a nationwide preliminary injunction asking the court to enjoin all defendants except President Trump from enforcing the executive order. The motion was granted by a federal judge on December 22, 2020. In January 2021, President Biden overturned the former president's executive order. When it comes to public school curriculum, state and local school boards have the control. The influence from the federal government could be limited. The federal government can influence curriculum only through the federal aid it provides. State legislature has the responsibility for curriculum determinations and impose curriculum directives that are not in violation of federal constitutional rights. According to a report on the website of Chalkbeat, as of February 2022, at least 36 states have adopted or introduced laws or policies that restrict the teaching about divisive concepts. With 2023 state legislative sessions underway, new legislation is in the pipeline. A few notes on the state laws on divisive concepts. First, many media reports use critical race theory to describe the state laws on divisive concepts. Please read the text in legislation and make your own judgment. Here is the definition of divisive concepts in Georgia. Divisive concepts means any of the following concepts, including views espousing those concepts. A. One race is inherently superior to another race. B. The United States of America is fundamentally racist. C. An individual, by virtue of his or her race, is inherently or consciously racist or oppressive toward other individuals of other races. D. An individual should be discriminated against or receive adverse treatment solely or partly because of his or her race. E. An individual's moral character is inherently determined by his or her race. F. An individual, solely by virtue of his or her race, bears individual responsibility for actions committed in the past by other individuals of the same race. G. An individual, solely by virtue of his or her race, should feel anguish, guilt, or any other form of psychological distress. H. Performance-based advancement or the recognition and appreciation of character traits such as a hard work ethic are racist or having been advocated for by individuals of a particular race to oppress individuals of another race. Or I. Any other form of race scapegoating or race stereotyping. Espousing personal political beliefs means an individual, while performing official duties as part of his or her employment or engagement with a school or local school system, intentionally encouraging or attempting to persuade or indoctrinate a student, school community member, or other school personnel to agree with or advocate for such individuals' personal beliefs concerning divisive concepts. Race scapegoating means assigning fault or blame to a race or to an individual of a particular race because of his or her race. Such a term includes, but is not limited to, any claim that an individual of a particular race consciously and by virtue of his or her race is inherently racist or is inherently inclined to oppress individuals of other races. Race stereotyping means ascribing character traits, values, moral or ethical codes, status, or beliefs to an individual because of his or her race. Many state laws on divisive concepts do not explicitly mention critical race theory. The legislative language leaves room for interpretation. Whether the targeted divisive concepts are within the true meaning of critical race theory is interpreted differently among people. It's important to note that critical race theory is not a single theory. It is a framework that centers around the idea that race, racism, and power are intertwined, and that systemic racism is deeply embedded in the fabric of society. Supporters of critical race theory argue that it provides a more comprehensive understanding of the ways in which race and racism operate in society. It goes beyond individual acts of discrimination by broadening the scope to examine how racism is embedded in the structures and systems of society. Following this line, you may hear arguments such as equity as preferable to equality, racial color blindness as racist, or meritocracy as racist. There are also arguments that have been made against critical race theory. Some critics argue that the theory's focus on race can pit different racial groups against each other, which perpetuates the very racial divisions it aims to address. Take meritocracy as an example. Some argue that meritocracy is a fair and just way to evaluate people's potential and achievement, and that it is a more effective means of allocating resources and opportunities than alternatives like nepotism or cronyism. What are the impacts of the state laws on divisive concepts on K-12 teachers' speech protection? We pay attention to three factors. The first factor is whether a teacher works in a K-12 school or a higher education institution. The Supreme Court considers K-12 schools as the nurseries of democracy and higher education as a marketplace of ideas. K-12 teachers do not have the same free speech protection that instructions in colleges and universities have. The different levels of free speech protection in classrooms can be traced back to the 1967 Supreme Court decision of Keyishian v. Board of Regents. In that case, New York State had laws that prohibited state employees from belonging to any organization that advocated the overthrow of the U.S. government or was treasonous or seditious. The Regents of the State University of New York required teachers and employees to sign an oath that they were not members of the Communist Party. Some faculty and staff of the university were terminated for refusing to sign the oath and appealed to the U.S. Supreme Court. The Supreme Court ruled in favor of the faculty members. Writing for the majority, Justice Brennan emphasized that a free discourse in college classrooms should be protected as a marketplace of ideas, a concept he labeled academic freedom. In a different Supreme Court decision of parents involved in community schools v. Seattle School District No. 1, the Supreme Court reasoned that universities occupy a special niche in our constitutional tradition, and the constitutional rules applicable in higher education do not necessarily apply in primary and secondary schools, where students generally do not choose whether or where they will attend schools. Academic freedom in K-12 classrooms has not been judicially recognized. The Supreme Court has held that balancing academic freedom is different for K-12 schools because of the special characteristics of the school environment, such as young students' immaturity and the public's interest in public schooling. Those characteristics call for a different balancing test that needs to recalibrate the weights of variables such as state interest, academic freedom, and individual rights to free speech in K-12 classrooms. The second factor is whether a teacher speaks as a private citizen or a public employee. Speaking on matters of public concern as private citizen, government employees, public school teachers included, have free speech protection. This came from the 1968 Supreme Court decision of Pickering v. Board of Education. In that case, Pickering was a public school teacher who sent a letter to the local newspaper, questioned the school board for its handling of school fund allocation, and accused the school superintendent of trying to suppress teacher criticism of the issue. Pickering signed the letter as a citizen, taxpayer, and a voter, not as a teacher. The school fired Pickering, who then appealed his dismissal. Because Pickering spoke on the matter of public concern, which was about school funds allocation, the Supreme Court ruled in favor of Pickering. The court emphasized that certain public employees may be the most informed citizen on certain issues of public concern. They need to speak on such matters without fear of retaliatory dismissal. Pickering's speech did not negatively impact workplace efficiency because it did not jeopardize his work relationships or interfere with his classroom on school operations. It is important to point out that in the Pickering case, Pickering's speech was not made in classroom. If the same speech were made in the classroom, one may argue that the court's decision would be different. The third factor is whether the speech is pursuant to a public employee's official duties. The Supreme Court dramatically narrowed the scope of First Amendment rights for public employees in Garcetti v. Ceballos. In Garcetti case, Los Angeles County District Attorney Ceballos wrote 2 memos describing an affidavit from his office that contained serious misrepresentations due to potential governmental misconduct. After a meeting with his supervisors, Ceballos experienced allegedly retaliatory actions, including reassignment and denial of a promotion. The Supreme Court's 5-4 Garcetti decision asked a threshold question: was the speech within the scope of employment duties? Because Ceballos wrote the memos pursuant to his official duties as a public employee, his speech was beyond the scope of First Amendment protection. Here are two cases in which courts applied Garcetti decision to deny First Amendment protection to speech made by K-12 educators in the classroom setting. In Brown v. Chicago Board of Education, Brown was a 6th grade teacher who caught students passing a note in class. The note contained music lyrics with the offensive N-word. Brown used it as an opportunity to conduct a well-intentioned discussion of why such words must not be used. The school principal happened to observe the lesson. The principal suspended the teacher for 5 days for using verbally abusive language in front of students, even though the teacher was trying to explain why the word was offensive and convey to students the potential harm of such language. The school principal argued that the teacher violated the school board policy that forbade teachers from using racial epithets in front of students, no matter the purpose. The Seventh Circuit upheld the discipline of the teacher. The court reasoned that Brown himself had emphasized that he was speaking as a teacher, an employee, not a citizen. An employee does not speak as a citizen when he makes a statement pursuant to his official duty. Brown gave his impromptu lesson on racial epithets in the course of his regular grammar lesson to a 6th grade class. His speech was therefore pursuant to his official duties. That he deviated from the official curriculum does not change the fact that he was performing his official duties as he attempted to quell student misbehavior. As a result, the school principal's suspension decision did not violate Brown's First Amendment rights. In Shelley Evans Marshall v. Board of Education of the Tipp, a teacher distributed a list to her students. The list was compiled by the American Library Association of the 100 most frequently challenged books. The teacher divided the students into 2 groups and asked each group to pick a book from the list to investigate the reasons why the book was challenged and to lead an in-class debate about the book. In the October school board meeting, 25 or so parents complained about the curricular choices in the schools. In the November school board meeting, nearly 100 parents as well as the local news media attended the meeting. In the meeting, a group of parents presented the board with a 500-signature petition calling for decency and excellence in the classroom. The matter did not end there. In teaching creative writing, the teacher had a file of student writing samples that she shared with the students who asked for additional guidance on assignments. One writing sample was about a first-hand account of a rape, and the other was a story about a young boy who murdered a priest and desecrated a church. The teacher's contract was not renewed. The 6th Circuit upheld the school board's non-renewal decision, holding that the Garcetti decision applied because the teacher was acting pursuant to her job duties, and the First Amendment does not extend to the in-class curricular speech of teachers in primary and secondary schools. To sum up, public school teachers cannot teach what they want in classroom. K-12 teachers have free speech protections when they speak on matters of public concern as private citizens, and when the speech is not pursuant to their official duties in classrooms. If teachers freely express their opinions in their classrooms and make instructional decisions that deviate from the approved curriculum, they could get in trouble. It is important that teachers familiarize themselves with their state law on divisive concepts and their school district policies.